attention.
May it please the court. Good morning, Your Honors. Thad Spalding on behalf of Rogelio Carlos and Myrna Carlos. I know this case centers on the exclusion of our medical expert in the trial court on a causation issue. I know the court has had questions on jurisdiction, and so perhaps...
Yeah, I would say this appeal is exclusively about jurisdiction. Go ahead.
Okay. So, obviously, the letter brief that the parties submitted didn't answer those questions. I went back, looked back through the record, trying to figure out where we went wrong. And I still believe that the court has jurisdiction over this case. I think there's diversity jurisdiction over the severed cause. But I think we could probably fix some things here on appeal that would make the court more comfortable that it does have jurisdiction and can address the merits of this case. I understand that the severed case, because it was ancillary or supplemental jurisdiction in the original cause, once it's severed, it has to have its own jurisdictional basis. There wouldn't have been diversity in the main cause, but once it was severed, the only severance was as to our clients who are Texas plaintiffs and Dr. VanNess, who is a North Carolina resident. Our complaint...
Are we looking basically at paragraph 12, or is there anything else that we should be looking at in the record?
No, paragraph...
I take your point that paragraph 12 is sufficient, and we'll deal with that in a moment, but...
Yeah.
I just want to get my arms around the universe here. Is it just paragraph 12?
It's paragraph 12. I looked back at Dr. VanNess's deposition that's in the record to see if there was anything in there. It references the fact that he was performing the neuromonitoring out of his home in North Carolina, but I mean there were no direct questions as to what his residence was.
And in fairness, back then you thought you had supplemental jurisdiction, so this wasn't a focus.
Right.
In other words, it's kind of plausible to see how we would end up here.
Exactly.
Nevertheless, we have to follow the rules, obviously.
Right.
So tell me, if we're talking about paragraph 12, why do you see paragraph 12 as sufficient?
Well, I think looking back at it, I don't think it is. We reference where Dr. VanNess can be served and that he can be served in North Carolina, and my recollection, and Mr. Waters can correct me if I'm wrong, but that was his home address in North Carolina. But I think 28 U.S.C. 1653 allows us to amend that and fix that on the appeal.
As I understand how that statute works, it's when we are confident on appeal that, look, there's jurisdiction, this is just a technical glitch, we can fix that. Why is paragraph 12 enough to tell us that we should be confident? I mean,
well,
he works in San Antonio in Texas, but he can also be served some other place. Right. That doesn't tell me where he lives. It doesn't tell me where he's a citizen. Or does it?
Yeah, I mean, I see where...
He could be Texan. He could be North Carolinian.
Well,
North Carolinian.
Right.
After last night, I should probably be more respectful. But we don't know, right? It's ambiguous.
I will tell the court this, in his answer, in Dr. VanNess's answer, he denies that he is employee of this entity in Texas or that he, has rendered services in the state of Texas. So that is denied, but he admits the rest of the paragraph.
But even then, he admits that he can be served at that particular address or anywhere else.
Yes. And that's the best we got until we have the joint letter brief of the parties. And I think that at least there's an agreement among the parties that he is a North Carolina resident. And so I think, and I found the case last night, Seguin versus Remington Arms, which was Judges Owen, Dennis, and Southwick. It's 22 F 4th 492, just from January 6th of this year. And that was a case, it was a diversity case where the court ran into a similar issue. It had to do with Remington and the allegations as to Remington's citizenship. I mean, there probably a little better facts in that case, but the court goes through a number of cases, a number of examples of ways in which this court can address that issue on appeal without just throwing the case completely out. And
Well, what are the three legal options? One is we throw it out, in spite of the fact that I think it's understood there was no mistake at the outset because there was federal question jurisdiction. It only pops up as a problem well after the complaint when there's the summary judgment and severance, right?
right.
So, but you still, the rule could just be harsh, even though it wasn't a mistake on your part, you're out. Or it could be what I think you're urging, which is that Burdett is our law and it's premised on 1653, and there's nothing about do we have to confirm something's more or less probable in the record. The parties can just amend their pleadings. You'd still have to prove it up. The third would be a mid-cap option, right? Which is you go back down, right? You've studied mid-cap 1 and 2?
I'm not going to pretend to know what mid-cap says, but I think...
It would be a remand for just jurisdictional confirmation.
Yes. Yeah, I think that would be another alternative. But the Seguin case, a little similar to this case in that they asked for a joint letter. There was a joint letter that addressed the membership of the LLC, which Remington was. They had not addressed in their complaint the membership of the members.
But that's like Burdett, isn't it? That's exactly what happened in Burdett. That was a mistake. The parties hadn't addressed something the law would suggest they had to.
Right.
You're not conceding you made a mistake here, just the way the case evolved.
Right. No, I think that's correct. But I think we can, I think the law allows us, the law of this circuit allows us to amend that. I mean, the statutory authority grants this court and the authority to ask us to amend now. Or, like you said, remand to fix that error. But I think where we're in a situation where I think diversity jurisdiction is less clear from the pleadings, but very clear from the parties' agreement and filings in this court, that we can fix that issue and the court can get to the merits of this case.
But the problem, I guess, is can we fix it here when I think there's an understanding it's not in the record. This is a post even appellate briefing, supplemental filing by counsel, not record evidence. So,
Well,
I mean,
but
I tend to think that we could fix it. It's just I don't know that let me rephrase, we, the judiciary, can fix it. Whether the Court of Appeals can fix it or not is the more troublesome question.
Well, I think we can fix it.
Right.
I think
We meaning you, the two of you. Okay, fair enough. Got it.
I think we can fix
That's
it.
a literalist interpretation of 1653. I do read the statute that way, but I am concerned there's case law that suggests we only allow you to do that when the record probably indicates that it exists. And it sounds like in the exchange here, it's sort of hard to point to that record proof.
Well, and I think the case, some of the cases that the court goes through in Seguin are instructive in that there are varying degrees of circumstances in which the record really reflected diversity jurisdiction or that the court had jurisdiction over the case. And so I think it indicates at least some flexibility in this court based on their interpretation of the statute that this court can allow issues like this to be corrected.
My panel may continue to ask you questions, but I would like to get to the merits. Is your position that Dr. Scalabassi, if I'm pronouncing his name right, would be qualified to say anything about what the surgeon would have spotted and would have been able to have done had he been alerted to the impulse impingement?
No.
Put the chart aside. What is it that you think your expert was not allowed to opine on?
Our expert was not allowed to opine on causation. And causation in this case means the timing by which the compression of the spinal cord could have been corrected by Dr. Bruggeman. Now, he's not going to testify, and he said he wouldn't testify to what Dr. Bruggeman would have seen, but this is a unique case in which we've got the testimony of Dr. Bruggeman, who went back in once he knew that there was an issue with the signals. And now it was after he had closed, and it was after he woke him up. And
How much time between signal stop and back in? How much time elapsed before he came out of being anesthetized, they did the CAT CT scan, they go back in? How much time?
I think that was almost 3 hours.
3 hours. And did you proffer what Scalabassi would have said is the window of time before you can never recover, that the paralysis is permanent?
Yes, Dr. Scalabassi said that you have, once you have that loss of signal, you have between 10 and 20 minutes.
Okay, and you're saying
Correct the issue.
his knowledge and experience is that the physiology of spinal cords is such that he knows that 15, 20 minutes, and at that point you can't restore. Is that?
That's correct.
That's the testimony you want to get in?
Yes.
And what's your best Texas sort of med-mal case where someone who's an assisting physician, and I'm thinking like a radiologist or an anesthetist, can testify to essentially what is it that they contributed to? The failure to cure? This assisting physician who actually wouldn't have, didn't chip off the bone.
Right.
Can you think of a case that sort of stands for the proposition you're arguing?
No, I can't. And I haven't. If I had found one, I would. I would have relied pretty heavily on it. But I don't know. This is a unique situation. Neuromonitoring cases.
Right, but it's not really unique, right? Anyone monitoring, a radiologist assists. If the radiologist doesn't happen to see the tumor, they would be contributorily negligent, maybe, to the ultimate failure to correct the cancer. Almost anyone in that assisting position, even just the airway, if you don't do the Heimlich maneuver in time, the person's going to die. But you don't have a case that says that the person who's supposed to do that.
Right. No, because I think here you've got. It's a little bit different from the radiologist who doesn't see the tumor, because here you've got a very narrow window of time in which something can happen, and the surgeon has to be alerted by the assisting physician to this loss of signal.
Even narrower window of time if the airway is obstructed. Someone has to tell the surgeon the patient's not breathing. None of those cases exist.
I have not found those cases. And so,
Okay, we'll keep going.
So but we've got, all Dr. Scalabassi is testifying to is based on his experience with the physiology, and it's just the timing issue. So once we don't need Dr. Scalabassi to testify to what the surgeon would or should have done, because we've got Dr. Bruggeman's testimony in this case.
Which is pretty equivocal, right? His testimony was, not sure I would have seen it.
Sure, but he would have gone back in. Had he known, he would have gone back in and he would have looked at
Gone back in or stayed in. He testified.
Well, yeah, they had not closed it. They wouldn't have closed at that point. So he would have, as he described, he would have kind of backed up his steps. And I mean, Dr. VanNess, Dr. Scalabassi, Dr. VanNess in his chat log, emphasized the fact that you need to remove the equipment and see if the signal is restored. I mean, so everybody's, with variations and certainly equivocation, the general consensus, if you will, is that once that signal was lost, cage is removed, and then yes, it's an issue of whether he would have seen the bone fragment. And Dr. Scalabassi says, based on Dr. Bruggeman's testimony, based on what he did in the second surgery to remove the bone fragment, and how he described in his deposition he would have gone back in and looked with a microscope, he believes that he would have seen the bone fragment and been able to remove it at that point.
Okay, counsel. Thank you very much.
Thank you.
Mr. Is it Waters? Yeah.
Good morning, Your Honor. Members of the court, may it please the court. On behalf of Dr. VanNess, I understand that the court has jurisdictional concerns in the case, as well as, of course, an interest in the merits. I will represent to the court that when we, counsel for the case, were first notified of the court's concern with jurisdiction, Mr. Spalding and I had a sort of informal conference regarding that issue, and we arrived at a sort of very rough, informal, I suppose, division of labor on the jurisdictional issues that we might look at. We are both very much in agreement that jurisdiction exists in this court based on diversity following the severance of the case. I looked primarily at issues relating to the Rule 21 and Rule 54B aspects of severance, the finality of the judgment following the severance, the effect of complete diversity once the non-diverse parties were settled out, and have some confidence, quite a bit of confidence actually, that under applicable Fifth Circuit case law, including particularly Crockett versus R.J. Reynolds Tobacco Company, that was at 436 F. 3rd 529.
436 F. 3rd what?
529, a 2006 case out of this court. It dealt with removal jurisdiction, but of course subject matter jurisdiction is always predicate to the ability to remove. The removal statutes simply add another layer of requirements on the part of the plaintiff, but everything must depend on subject matter jurisdiction at that point. This was an interesting case because it involved two sets of defendants, a health care set, as we have here, and an active tortfeasor set, in that case the tobacco companies. Once they were severed, this court arrived correctly, it seems to me, at the conclusion that there was complete diversity of jurisdiction following that severance of the non-diverse parties, and pursuant to Rule 21 and 54B, the judgment could properly become final, as it was here. With regard to Section 1653 on the ability to amend, that has already been discussed somewhat. I think it was interesting, though, one case I did find, a U.S. Supreme Court case that sort of addressed the 1653 issue somewhat in passing because it dealt more with the ability of the appellate courts and the jurisdiction of the appellate courts to effect a severance rather than to rely on amended allegations. In other words, they were curing the merits of a jurisdictional issue through severance rather than looking simply at how the jurisdictional issues were pled. The Supreme Court did say and remind the parties in that case that under 1653 there is this ability to always to be able to amend the pleadings so that they can be more concretely persuasive as to the jurisdiction of the parties, and certainly we agree that that can be done here.
Don't hold us in suspense. What's the case? And I'm not faulting you because all you did was file a letter brief by our request. So there's really been no briefing on this issue. But so good for you both to find new cases. But what's the Supreme Court case you're referring to?
Newman Green versus Alfonso Lorraine, and that's 490 U.S. 826, a 1989 case. We believe, and I think I would agree with Mr. Spalding, that the error can be cured here by way of further stipulation or supplemental briefing on the part of the parties, and we would be happy, both of us, I'm sure I can speak with Mr. On behalf of Mr. Spalding. Do
you have familiarity with the mid-cap?
I do not. That was sort of not part of my remit on what we were.
It's just, one could read Burdett, albeit a footnote, just to support what you're arguing now, just the plain text of 1653. On the other hand, this mid-cap line of case law suggests that if we have uncertainty, we're going to send it back and let the district court do it.
And I'm certain, Your Honor, that to the extent there is such an uncertainty, the district court, I'm sure, would be perfectly capable, particularly given the cooperation of the parties and joint submissions of the parties.
Could we even hold jurisdiction ourselves if we send it back? It gets a little tricky.
It does, in terms of whether the, and to be honest, I'm thinking more, I guess in the back of my mind, in terms of state appellate jurisdiction. There would not be a problem in that arena with doing that. The state appellate rules have that provision in which a case can be remanded in part for clarification of the record and certain issues on the record, and then will be received back at the court. And to be honest, Your Honor, I would have to look, and certainly, again, if the court would desire some brief additional supplemental briefing on these mechanical aspects, I'd be happy to do that. In fact, I'd be happy to cooperate with Mr. Spalding in coming up with a joint submission.
Well, if we need supplemental briefing, we'll inform you
Okay.
after we have time to conference.
Oh, certainly, Your Honor. Your Honor, with regard to the merits of the case, just briefly, I think this is not, at bottom, a particularly complex issue that we're dealing with, and quite honestly, a surprisingly significant component of the merits of this appeal, I believe, turns on what the parties do agree on, and in particular, with respect to what Dr. Slobosky has testified to and what the appellants themselves, Mr. and Mrs. Carlos, have expressly stated in their briefs. First of all, while this is an appeal from a summary judgment, the standard of review is not in practical effect according to the Rule 56 standard of no genuine issue of material facts, since in this case the parties agree that summary judgment had to be granted if the plaintiff, Mr. Carlos's sole causation expert, Dr. Slobosky, was properly stricken as to causation testimony. And in fact, they expressly state that in their brief. And as they further state, Dr. VanNess agrees with this. The issue for review in this appeal is simply, did the district court, which is the gatekeeper of expert testimony, abuse its discretion in so limiting Dr. Slobosky's testimony? And we respectfully submit that on this record, it really cannot plausibly be argued that both the magistrate judge and the district judge abused their discretion in that regard.
But he was excluded based on unreliability, so I wasn't clear when I read the hearing. It didn't seem like anyone was challenging his qualifications. He's pretty qualified, at least as to the physiology of a spinal cord. So what was unreliable? I mean, in a very lay sense, I'm thinking he just wanted to say time matters.
He did want to say time matters, but the problem was that he was not able, based on the record that he had to work with, including Dr. Brueggemann's testimony, that it mattered in such a way as to bring about a particular causative effect here. And in that regard, Your Honor, I think the testimony of Dr. Brueggemann is particularly important for two reasons. Number one, Dr. Brueggemann testified, and I think this is around page 46, 47, 48 of his deposition, if I'm recalling, but we've discussed it in our brief. He testified about the three types of evoked potentials that could potentially have been involved in this case. We only had two of them here. The three types were the electromyography, purely electrical nerve stimulus sort of thing that he talked about, which was used here, which Dr. VanNess organized at his office in North Carolina from his home. There was what's called SSEPs, somatosensory evoked potentials. And then there was a third metric that he mentioned. This was motor evoked potentials. This was, as Dr. Brueggemann described it, the gold standard of evoked potentials neuromonitoring. This is what he really would like to have had because, and this is important, it's instant feedback. There's no lag time. Unfortunately, as Dr. Brueggemann said, the reason why he did not order MEPs, motor evoked potentials, in this case, was because of his review of the records on Mr. Carlos and the indication that sometime in his youth, Mr. Carlos apparently had suffered from a brain aneurysm of some kind, And there is literature.
Why is all this relevant to whether or not Dr. Skolbatsky can say, based on his experience, 3 hours is too long? Why wouldn't that just be like a paramedic saying, hey, 30 minutes is too long with the obstruction in the airway? Why, right? There was a level of incredulity in the hearing that seemed compelling to me, which is you're paying $60,000 for a neuromonitor, but are you essentially saying that doesn't contribute at all to the fact that 3 hours elapsed?
Well, the 3 hours lapse, we would respectfully submit, cannot be laid exclusively to the feet of Dr. VanNess.
I agree.
Now, one point that has to be borne in mind, I think, is
That's a jury question, isn't it?
Well, not necessarily, Your Honor. When we leave out the motor evoked potentials that I was talking about, we're left with the EMG and the SSEPs. The problem here is that with the SSEPs, as Dr. Brueggemann testified, there is a 15 to 30 minute lag time between the time the actual sensory impulse is generated by the body and the time it shows up on the neuromonitoring device. And the reason that's important is because even if we assume that 3 hours is too long, Dr. Skolbatsky was not able to testify, and he specifically indicated in deposition, as we discussed in the brief, he was not able to testify how long is too long. It would certainly have been some area that is less than 3 hours. And I think Mr. Spalding had indicated that there was at least a range that Dr. Skolbatsky has testified to. I believe it was between 10 and 20 minutes,
Right.
at which it becomes too late to
Right.
do anything.
Okay.
So the 3 hours is not really the issue. The issue is, could something have been done during that 10 to 20 minute time frame
Okay.
that Dr. Skolbatsky was talking about, in which Mr. Carlos's paralysis could have been avoided? In order for Dr. Skolbatsky to say that, he would have to have been able to say, I looked at the SSEPs, the somatosensory evoked potentials in this case, and because of when they arrived, we can say it was in the period of time within the window when this could have been done. We don't have that testimony here. We don't have a placement of that 10 to 20 minutes into a specific time frame in which Dr. Skolbatsky says the lag time collapsed. There's a lag time of between 15 and 30 minutes, according to Dr. Brueggemann, and we don't have anything in the record to collapse that back into a position where it would have been sufficient. If there was a 30-minute lag time in the SSEPs in this case, then it was already too late to save Dr. Carlos. And the reason it was too late to save Dr. Carlos is because the immediate feedback response that could have saved him from paralysis, the MEP, was not available. Okay. Dr. Brueggemann did not order it, would not order it, because it's contraindicated. In fact, he said in his testimony that,
But how does
and
this
that very
Okay.
that very question was raised in his deposition. Well, what good does it do anyway? What good does Dr. VanNess do in being able to do this if you don't have the motor evoked potentials? And Dr. Brueggemann said, well, you want an SSEP sometimes for positioning purposes. It can give you some indications that, for example, a hand has gone to sleep because of the way the body has been positioned. There is a non-responsiveness in some part of the body that's governed by the portions of the spinal column that the SSEP addresses on this.
Do you have any case law? You heard me asking for case law.
Case law, no, Your Honor.
So there's no case law. I mean, it's the doctor wants to get on the stand and say, in my professional opinion, being decades with spinal cords, neuromonitor has got to alert within 30 minutes of the last signal, or otherwise that negligence, the neuromonitor's negligence of not alerting, has contributed to the injury here for us.
And again, just as with Mr. Spalding, I was not able to locate a specific case on that. Part of the reason for this, I think, Your Honor, is that neuromonitoring, which is really not a specialty itself, as Dr. Slobosky testified, he doesn't have a board certification in anything. He is familiar with neuromonitoring because that's what he does, but it's a fairly new endeavor in terms of how this relates to neurosurgery and the relationship with neurosurgery. There probably has not been enough time, quite honestly, for a substantial body of case law to be developed on this. I think we're back to the Rule 702, Rule 703, Rule 601 incorporating the state standards in this. We're back to that area of assessing both the qualification and the reliability of the testimony. To the extent there were challenges on qualification, much of this is based on what came out of Dr. Slobosky's own mouth in his deposition. He testified, again, as we discuss and cite in our brief, not just as to standard of care, but also as to causation, when he testified specifically that he had never been called upon to offer an opinion as to causation of injury to the spinal cord due to a surgical procedure itself. Not only did he testify that he had never been called upon to do that, but he agreed that the only qualified specialty to do that would be a neurosurgeon. He did not, he expressly conceded he would not consider himself qualified to do that. But I think that, separate and apart from that, it's the reliability of the issue. The fact that he could not say for certain at what time it became too late, the paralysis became permanent. And he, again, expressly admitted, as we discuss and cite in the brief, that he was not able to assign a time to that. All he can say is that if things had fallen properly into place, if we got lucky on the SSEP lag time and it was only maybe 5 or 10 or 15 minutes, and Mr. Carlos was particularly tough and rugged and was able to withstand this pressure on the spinal column for maybe up to 20 minutes. If all of those cards fell into place, and if Dr. Brueggemann, when he went back into the spinal cord, was able to see these bone fragments without the benefit of a prefatory CT scan, and he testified at 109 and 110 of his deposition that he may very well not have been able to see these, even if he had gotten instant feedback. And in fact, he was testifying to this in the context of MEP, even if he had done an MEP, and even if he had gotten an instant MEP feedback, he may very well not have been able to detect the bone fragments when he went back in without first doing a CT because of the way they were placed and the almost invisibility of what he was dealing with there. That's why we had indicated in our brief that it would have been an uphill battle on this record, and based particularly on Dr. Brueggemann's testimony. It would have been an uphill battle, I think, for any expert to be able to establish causation, but certainly, in any event, Dr. Slobosky was not the one to be able to do that, based on what he testified to as to his own limitations and what he testified to, again cited chapter and verse in the brief, as to his own speculativeness over what Dr. Slobosky would have been able to do. In fact, at one point, and we quote from this verbatim in the brief, he says that he's basing his opinion on what Dr. Slobosky would have done, on what a reasonable neurosurgeon would have done, and then 2 lines later, he actually says, I don't know whether Dr. Brueggemann would have been a reasonable surgeon or not. Would you have to be speculating on that, Dr. Slobosky? Yes, sir, I would. So all of this is from Dr. Slobosky himself. It would have been difficult, maybe not
What's the
impossible.
standard of review for exclusion of?
Abuse of discretion. It's the gatekeeper standard established ultimately under Dalbert. So, and that's why why I was indicating we were not really dealing here with a Rule 56 standard, because we agree. If Scalabasi is in, we're okay. If Scalabasi is out, then
Yeah. Thank you very much.
thank you.
Mr. Spalding, rebuttal?
Thank you, Your Honor. Real briefly, just to go back, I wanted to bring up one thing on the jurisdictional issue. There's a case, again, it's cited in that Seguin case that I mentioned earlier, and it's called Kaufman versus Western Union. It's a case from the Fifth Circuit, 1955, 224 F. 2nd, 723.
It's a F2nd case, 1955,
Yeah, I think
F2nd what?
F. 2nd, 723, and I think the jump page is 735. Maybe 725, can't read my own writing. But in that case, the court references the ability to look outside the record for jurisdictional purposes, but then it also ordered the parties to amend their complaint within 10 days. So that could be additional support for addressing the jurisdictional issue here. With regard back to the merits, I just want to address a couple things that Mr. Waters brought up. The issue with regard to these SSEPs and MEPs, that's kind of a new argument that wasn't really addressed in the trial court, and Dr. VanNess has raised it now on appeal. But I don't think it impacts the admissibility issue of the expert. If there were signals, if there were issues with regard to timing of the signals, that would certainly impact the weight of the testimony, but not its admissibility. But on top of that, it's not an issue in this case. And I find it interesting that Dr. VanNess is now trying to claim that the surgeon is the expert on the neuromonitoring signals. But both of the neuromonitor physicians in this case, Dr. VanNess and Dr. Scalabasi, both agreed that even the SSEP signals can be within seconds or minutes. In fact, in Dr. VanNess's chat logs, which are in the record at page 1878, he was asked by Dr. Bruggeman how long, through Mary Bell Gomez, who was the technician, he was asked how long it would take the SSEPs to respond to a change, and he said it could take a few seconds to a few minutes. And then Dr. Scalabasi, in his deposition, also said that Dr. Bruggeman's statement that there is this lag time between 15 and 30 minutes is not supported by the technology. That you do have, and the chat logs support this. If you look at the timing on the chat logs, there are references to an immediate or near immediate, maybe within a minute or two of the loss of signal or some substantial impact to the signal right after the equipment, the cage, is being placed on the vertebrae. And that is what, at least so far, everyone has really agreed is the operative causal issue. What caused the bone fragment was the placement of the cage. And so once that happened, there were, and Dr. Scalabasi testifies this too, that those are the changes of signal. And when those changes of signal were indicated, they should have been immediately brought to the attention of the surgeon, and they weren't.
So it's not, he wasn't going to testify anything about what Dr. Bruggeman would have done or could have done or should have done. It was simply that the neuromonitor's failure to alert him for 3 hours was contributory to the failure to cure. Is that?
Yes.
Yes? Think about that. That's what you wanted him to be able to testify to?
Well, Obviously, the surgeon's not going to go back in unless.
No, I know the common sense argument. I'm just really asking, what is the question and answer you wanted to ask Scalabasi that you were prohibited from asking?
We want, I mean, he is allowed to testify that Dr. VanNess there was a standard of care that required him to.
I know, so what wasn't he allowed to say that would have been causal to the ultimate injury here?
That had Dr. Bruggeman, had Dr. VanNess informed Dr. Bruggeman of this change in signal, Dr. Bruggeman would have gone back into the patient within this window of time. And that's the crucial aspect of Dr. Scalabasi's testimony, is this window of time that he had available to him to go back in and remove that bone fragment.
Thank you, counsel.
Thank you.
Case is submitted. Keep going? Whatever you want. Let's keep going. Okay, great. We will continue.